Thank you so much for coming to the finals of the Criminal Cup of the 4 Institutes Moot. Today's judges are His Honour Judge Simon Heptonstall, Mark Robinson, and Tamala McKee. Thank you so much for coming once again. And today's counsel are in the following speaking order: Senior Appellant Elif Burkay, Senior Respondent Jane Chan, Junior Appellant Maria Drano, and Junior Respondent Maria Brewer. The Senior Appellant will introduce all counsel once again after the moot begins. Now I remind everyone to put your cameras, put your phones off, or in silent mode, or in the not disturb it mode. And audience members are allowed to take photos, but not of the judges, and no recordings, please. If you take photos, please do it on silent and with no flash on. All counsel will have 15 minutes to speak. Judicial interventions, of course, are highly encouraged. And I will raise an open hand when the advocate has 5 minutes left. I will raise one finger if it's 1 minute left. And I will raise an open hand again when the end has, when there is the end of the submission. There will be no extra time for replies, so if counsel wish to do so, please use your allotted 15 minutes. At the end of the junior respondent, the judges will briefly deliberate to give a judgment as well as give oral feedback. The winning team will be announced today. Yes?
Hope so.
Let's hope so. And we will arrange a date before the end of the month to give the engraved shield as far as the points breakdown. These will be posted in the website as well as the Instagram account. The awards for the top advocate and the top bundle will be announced before the end of the month too. Good luck to all of those today. Let me put the timer on and we can start all together.
May it please the court. Myself and my junior counsel, Miss Jano, appear on behalf of the appellant, and my learned friends, Mr. Chan and Ms. Brewster, appear on behalf of the respondent. My lords, the appellant seeks to appeal the decision on the Court of Appeal on 2 specific points of law. I will be submitting the first point, that the appellant's use of force was lawful under self-defence, and that the court cannot rely solely upon the duty to retreat. Instead, a possibility of retreat should be repeated only as a factor in the court's consideration. It is therefore submitted that the Court of Appeal's judgment was unduly harsh, as it relied overly on the duty to retreat instead of treating it as a factor. My junior counsel, Ms. Jano, will be addressing the second point, in that the court, when determining whether the appellant's use of force was reasonable, the court must find that the defendant was provoked by BPS, which is battered person syndrome, and consider it evidence of what she honestly and instinctively thought was necessary under the Criminal Justice and Immigration Act 2008. It is submitted that the force used by the appellant was lawful under self-defence. The appellant's right to act on her genuine belief that pulling the rope was necessary is protected, even if the belief was mistaken. Before I begin my submissions, can I just check that the court has had the opportunity to read the bundle listed in paragraph 2 of our skeleton argument?
Yes, thank you.
I'm grateful. My lord, with your permission, may I dispense with full case citations?
Yes.
I'm grateful. Lastly, the factual background is available from paragraphs 3 to 11 of our skeleton argument. However, may I ask if the court would prefer for me to outline the facts before I begin?
No, thank you.
I'm grateful. I'll now move on to my submissions, which concern the lawfulness of the appellant's use of force and the duty to retreat. If I could just direct the court to paragraph 12 of our skeleton argument, which sets out the elements of an offence of murder. As the court is aware, murder is when a person unlawfully kills any human being with malice. It is submitted that the mens rea of the offence has not been fulfilled, as the appellant lacked the intention to kill. If I could just, sorry.
Ms. Becker, is that one of the grounds on which permission has been given to appeal to this court?
Sorry, can you repeat the question again?
The Court of Appeal has certified 2 points of general public importance, general public importance. Is the lack of intention one of those points of law?
Thank you, my lord. No, it's not one of those points of law. I was merely trying to introduce the subject of murder before covering the grounds duty to retreat. I'll move on if my lord.
But why is it, if you're introducing it, why is it, does it have a submission? It's part of the background.
I'm grateful, my lord. It's just part of the background information. However, I will move swiftly past that if my lord deems that necessary. I'm grateful. If I could just direct the court to paragraph 14 of my skeleton argument, where I'll be taking the court through the relevant subsections of section 76 of the Criminal Justice and Immigration Act. Section 76, subsection 3, asks the court to consider the reasonableness of the degree of force used by the appellant, and is to be decided by reference to the circumstances as the appellant believed them to be. Subsection 4 asks the court to consider the appellant's belief as regards to the existence of the circumstances, and if it is established that the appellant's belief is reasonable, and the appellant genuinely held the belief, the appellant is entitled to rely on their belief, whether or not it was mistaken or a reasonable mistake to have been made. Finally, it is submitted that as per subsection 7, a person may not be able to weigh to a nicety the exact measure of any necessary action, and that the person doing what was honestly and instinctively thought necessary for a legitimate purpose constitutes strong evidence of reasonable action. I will now move on to my main submission in considering whether there was a duty to retreat. I will begin my submission by considering whether the degree of force used was reasonable, as per section 76(3). I will then move on to the appellant's right to act upon her genuine belief, as established in subsection 4, before concluding my overall submissions. Firstly, in considering whether or not there was a duty to retreat, it is submitted that the court should first consider whether the degree of force was reasonable.
Doesn't that put the cart before the horse? Because isn't the question first, what did or might the defendant honestly believe? And then it's in those circumstances that the reasonableness has to be assessed.
I'm grateful, my lord. I was merely following the order suggested under section 76 of the Criminal Justice Act. That comes under subsection 3, and I was going to take the court according to that. However, if you prefer, I could do it in a reverse order.
You take it in the order that you think, but logically somebody doesn't the fact finder have to decide what the defendant did or may have honestly believed before deciding what was reasonable in those circumstances?
I'm grateful. I was merely following the order here. However, I'll very happily do it in a different order if you prefer.
Right.
If I could just ask the court to go to paragraph 15b of my skeleton argument. It is submitted that the appellant, by pulling the rope as hard as she could, used a reasonable degree of force given her stressful circumstances. Paragraph 15b references the case of Palmer v. the Queen, which states that a person defending himself cannot weigh to a nicety the exact measure of his defensive action. If the jury thought...
I seem to keep interrupting, but Palmer is effectively codified in section 76(7)(a), isn't it?
Yes, it is, my lord.
So what's the point of a pre-codification authority?
I was given that in my instructions, my lord, to quote that under point A, duty to retreat.
Okay.
So I was merely doing that as a preliminary portion. Brilliant, thank you. If my lord prefer, I can skip through that.
Continue.
If a jury thought in that moment of unexpected anguish a person attacked had only done what he honestly and instinctively thought was necessary, that would be the most potent evidence that only reasonable defensive action had been taken. In application to the facts of the case, the appellant pulling on the rope as hard as she could to reach the boat is submitted to be a reasonable response to the immediate threat of drowning. The fact that the appellant is a swimming instructor does not negate the immediate fear and disorientation she experienced upon being thrown into the water by her abuser. The appellant's actions were not premeditated, but instead a spontaneous reaction to the sudden threat. The suggestion that the appellant's behaviour indicates a desire for revenge overlooks the immediate threat she faced upon being thrown into the water. In the chaotic moment of being submerged into the lake, the appellant's primary objective was survival. Furthermore, the appellant's subsequent actions of sitting on the dock must be viewed within the context of her immediate survival and aftermath of a traumatic event. The argument that she had malicious intent to kill is overly speculative, with nothing from the facts of the case to support this claim. There is no evidence that the appellant set out to provoke the deceased or to engineer a situation where she could respond with violence. Her actions were a direct response to the threat posed by being thrown into the water. Furthermore, it is submitted that the court should adhere to the lenient wording of section 76(6)(a), which is set out in page 15 under section C of the bundle. Under page 15, section C. Can I just check if the court needs another moment? I'm grateful. Section 76(6)(a) addresses that the possibility that the appellant could have retreated is a factor to be taken into account rather than giving rise to a mandatory duty to retreat. Therefore, in application of this lenient wording, it is submitted that the Court of Appeal's reasoning that the appellant could have swum to the shore instead of pulling on the rope is unduly harsh. The possibility that the appellant could have retreated by swimming to the shore should be considered a factor, but does not impose a duty on her to do so. Section 76, in conjunction with the precedent set in Palmer, recognises that in such urgent situations, a person cannot be expected to weigh their responses with perfect judgment to retreat if they genuinely believe that doing so would increase their risk of harm. I now go on to my second submission, in that the appellant had a genuine belief that her pulling on the rope was safe, and she had the right to act upon this genuine belief. If I could just ask the court to find paragraph 24 of my skeleton argument. I believe it's on page 11. At first instance, it submitted that the appellant, upon seeing the rope submerged in the water, grabbed it without realising that Gunner was holding onto the other end. There is no indication in the facts of the case that the appellant was aware of Gunner holding the rope. The appellant's belief in the necessity of her actions remains a crucial point. She believed that the rope was her best chance of reaching safety, as the boat was closer to her than the shore and provided a stable platform for her to regain her composure. Her perception was that she was in imminent danger of drowning. She had just been thrown into the water by her abuser and was in a state of shock at the time. Even if the court finds that Gunner did not intend to harm her further and was merely holding the rope to secure the boat or her safety, her actions were taken in a state of urgency. Can I just check if the court's with me so far?
Yes.
I'm grateful. If I could just ask the court to find paragraph 27 of my skeleton, where I apply the precedent of R.V. Gladstone. R.V. Gladstone Williams, supported by Harvey, acknowledged that it's not a question of reasonable apprehension of danger, but of the defendant's perception of the events and of the danger he believes he faces. In summary, Harvey directs the court to evaluate the situation from the appellant's perspective, considering her state of mind and the danger she believed she was facing. The President acknowledges that a person in such a scenario is acting under immense pressure and fear, which can cloud judgment and necessitate quick, instinctive actions. To conclude my overall submissions, it is submitted that the appellant's primary concern was her immediate survival. The appellant saw the rope submerged in the water and instinctively pulled on it, believing it was her best chance to reach safety and avoid drowning. Mistakenly, she did not see Gunner holding the rope. Years of abuse will have heightened the appellant's perception to threat, and the sudden shock of her immersion into the lake induced a state of panic. In such a situation, rational decision-making is severely impaired and should not be the deciding factor of whether the appellant committed murder.
How does the background of abuse, and maybe Eugenie's going to deal with this,
Yes.
impact on perception of threat when the case that you're submitting to us is a mistake?
I'm grateful, my lord. My junior will be delving further into the background of abuse, if you wouldn't mind.
All right. Thank you.
I'm grateful. If the court doesn't have any further questions, I'll hand over to my junior.
Yes.
May I please the court? I appear on behalf of the Crown as senior respondent. Before I proceed with my submission, may I check that the bench has the respondent's bundle? If I may refer the bench to page 7 to 13 of the respondent's bundle. My lords, my lady, I have two submissions to make. The Court of Appeal was right that the appellant could not rely on self-defense for two reasons. Firstly, the use of force was excessive, and secondly, the use of force was pursuant to revenge. My lords, my lady, you will find my first ground of submission in page 11 to 12 of the respondent's bundle, paragraphs 11 to 14 of the respondent's bundle. Is the bench with me?
Yes, thank you.
In analyzing whether the use of force was even necessary or reasonable, it is submitted that the context of where the crime took place is crucial, which I've cited the case of Crown and Ray. If I may direct the bench to page 30 of the respondent's bundle.
30.
Sorry?
30.
Yeah, 30. Sorry.
Which paragraph on page 30, please?
Paragraph 38.
Yes.
Which is a passage by Lord Chief Justice Thomas. In this case, the defense of self-defense is considered in the context of household cases. However, Lord Chief Justice Thomas gave us a guideline as in assessing whether the use of force was proportionate and reasonable. If the option of threat is limited or unlikely to arise, a disproportionate use of force could nonetheless be assessed as reasonable. It is important to contextualize where the crime took place. The crime took place at the Bay in the Lake District on the 2nd of June, between 4:45 a.m. to 6:20 a.m. In June, there will be ample morning light by 5 a.m. The crime also took place in a public area, and there was indeed a passerby at the crime scene at 6:20 a.m., indicating that the bay might not be too remote for public access. It is also important to note that before the deceased was drowned, he wanted to swim in the bay, indicating that the depth of the bay was safe for wild swimming. Also, the appellant worked as a swimming instructor at a local leisure center before, suggesting that she possesses the ability to swim. Applying the context analysis in Crown and Ray, the respondent invites the bench to place emphasis on the fact that there is an option for the appellant and the use to retreat, and the use of force was excessive. The appellant was not in imminent danger of drowning when she was thrown into the bay, as she could navigate the water to reach safety, as rightly concluded by the Court of Appeal. In assessing whether the use of force was excessive and reasonable, one should consider the circumstances in which the appellant pulled the rope. If I may direct the bench to page 33 of the respondent's bundle. My lords, my lady, you will find paragraphs 28 and 29 of the case of Crown and Harvey. Even though the use of force is to be judged from the perception of the appellant, it also involves an objective evaluation of the facts, which does not involve the appellant's own perception. It has to be judged at the moment when the appellant was thrown into the bay. Although the act of throwing the appellant into the bay would induce a panic attack, that might be true for a normal person. However, if it involves an objective evaluation of the facts in this case, in assessing whether the use of force was reasonable and proportionate to the threat, it is submitted that the fact that the appellant's work as a swimming instructor has significantly reduces the likelihood of her drowning. As a swimming instructor, she possesses fundamental swimming techniques and being prepared to respond to emergencies. My lords, my lady, at the time when the appellant
Would a
was...
swimming instructor be familiar with the principle of cold shock?
Sorry, could you...
Would a swimming instructor be familiar with the principle of cold shock? So, rather than entering the water using all the skills that she had and adjusting her body to it for while swimming, when thrown into cold water, the body may go into shock, and it's something that lifeguards are warned against.
Yes, that will be the case, but because she possesses some swimming techniques that will mitigate the risk of her being drowned, at least. My lords, my lady, at the time when the appellant was thrown into the bay, the deceased was merely holding onto the rope when he untied the boat. The deceased was not pulling or resisting when the appellant pulled the rope, and the dock beside the bay is wide enough only for two people, and there's a wood stump near the top end of the deck. With this context in mind, my lords, my lady, and to conclude my first ground of submission, it is submitted that the appellant's choice to pull the rope as hard as she could amounts to an excessive use of force. Concussion caused by hitting the wooden stump is a foreseeable consequence, given that the layout of the dock is narrow, indicating limited space for the deceased to maintain his balance after a sudden and forceful pull by the appellant. My lords, my lady, if I may move on to my second ground of submission.
Just firstly, so you're saying that it was reasonably foreseeable that the appellant pulling the rope that hard, the injuries would have resulted to the deceased?
Yes, it is the respondent's case that it is reasonably foreseeable that the deceased will be concussed and drowned, because at that time the deceased was not resisting the rope. So a sudden pull, and it is submitted that a sudden pull of the rope would drag the deceased into the water, or at least hurt the deceased.
It's fair to say, not a facetious question, the deceased could have let go of the rope at the time.
Sorry?
Would it be fair to say the deceased could have let go of the rope at the given time when the rope was pulled?
Yeah, but it is not the case in this situation here.
You continue.
Okay. Thank you.
Before you do, can I ask you to respond to Ms. Burko's point that grabbing of the rope may have been a panic reaction and to try and gain some kind of hold on something, having been thrown into the water?
Grabbing the rope is an instinctive reaction. However, it is submitted that when she pulled the rope as hard as she could, that would indicate a motive to revenge, which ties into my second ground of submission. My lady, if I may move on to my second ground of submission. Thank you, my lady. My lords, my lady, you will find my second ground of submission in page pages 12 to 13, paragraphs 15 to 19 of the respondent's bundle.
Before you start there, I'm just ensuring that I have it, because your bundle that you produced was 157 pages long, is that correct?
Yes.
And you start at 12, page 12 did you say?
Yes, page 12.
And what paragraph is it?
15 to 19.
The use of force was pursuant to a revenge.
Yes.
Thank you very much.
The respondent accepts that there is no duty to retreat. A failure to retreat is simply a factor to be taken into account, as lucidly submitted by my learned friend, the senior counsel for the appellant. However, in the case of Crown and Bird, Lord Chief Justice Lane cited a passage by Smith and Hogan, which is in page 28 of the respondent's bundle, paragraphs B to D. Is the bench with me?
Yes, so we're going back to the first point, not moving on to revenge.
Yes.
Are we?
Even though there is no duty for the appellant to retreat, a strong inference could be drawn that the appellant was not acting in self-defense if she used force by way of revenge. Before the deceased was drowned, the appellant initiated a series of provocative acts. If I may direct the bench to page 12, paragraph 17 of the respondent's bundle. Your Lordships and Ladyship will find a summary of the essential timeline of the crime. My learned friend, the senior counsel for the appellant, submits that it was a mistaken belief that she had to pull the rope as hard as she could to get to safety, and years of abuse would have heightened the appellant's perception to threat. The respondent humbly submits that the appellant was not acting in mistaken belief, which leads to my next point. My lords, my lady, the whole incident lasted approximately more than 30 minutes, which was from 5:45 a.m. to 6:20 a.m. The appellant did nothing to rescue the deceased. The appellant was able to get back to safety. She sat at the dock with her son while the deceased's body was still floating. The appellant did nothing to rescue the deceased until 6:20 a.m. when a passerby noticed the deceased's body and called the emergency call. Years of abusive relationship further strengthens the appellant's motive to revenge. Therefore, she was not acting in self-defense, as rightly concluded by the Court of Appeal. It was the appellant's deliberate choice to let the deceased suffer and ultimately drown. To conclude my second round of submission, the force used in the pursuit of revenge. The force was used in the pursuit of revenge because there was a confrontation between the appellant and the deceased before the incident. The appellant's motive for revenge is further evident in her failure to rescue the deceased, despite having the opportunity and ability to do so, which underscores a malicious intent to kill the deceased. Unless I could assist the bench any further, this is the end of my submission.
One question, was it reasonably foreseeable that the deceased would throw the appellant inside the lake?
It was not reasonably foreseeable because it's a consequence of the heated argument between the appellant and the deceased before the incident took place.
But you still maintain that this was revenge based on something that wasn't reasonably foreseeable in the first place?
This is the respondent's submission.
Very well.
Okay.
Thank you.
May it please the court.
Following the submissions of my senior counsel, I will address the court on the appellant's second ground of appeal. Before I start my submissions, my lords and my lady, I wish to deal with the confusion on what this ground of appeal actually entails, if I have your permission. I'm grateful. The appellant today did not wish to raise a partial defense of loss of control. It is the appellant's submission that the accused should be fully acquitted based on her acting in self-defense. In order to assess whether the force the appellant used was reasonable as part of her self-defense, the appellant seeks to persuade the court on the following 2 points. First, that the appellant was provoked by her experience of the battered person syndrome. The term provoked was submitted by the appellant to mean reacted on the basis of, which was similarly used in the case of Martin, and was not meant to plead a partial defense of provocation, now known by statute as loss of control. Second, the appellant seeks to persuade the court that the appellant's experience of battered person syndrome should be considered as evidence under Section 76 of the Criminal Justice Act 2008. Can I please direct the court to page 15 of the printed bundle? My lords, my lady, you should have before you the relevant paragraphs of Section 76. In paragraph 2 of the section, it is clearly stated that this section applies to a defense of self-defense, not a partial defense of loss of control. Paragraph 3 states that whether the degree of force used was reasonable should be decided by reference to the circumstances as the defendant believed them to be. Following that, in deciding what these circumstances were, paragraph 7b allows for the introduction of evidence that can show how the defendant did what they thought was necessary. It is under this paragraph, my lords, my lady, that the appellant requests the court to consider the appellant's experience of battered person syndrome. Unless the court has any questions, may I proceed with my submissions?
So in relation to subsection 3 then, what were the circumstances that the defendant believed to be in existence?
Thank you, my lady. The circumstances which the appellant believed to be true at the time was that the deceased threw her into the water. That event was a trigger event to a cycle of events of abuse, signifying that battering would follow. And that is where battered person syndrome comes into play. Does that satisfy the court?
Thank you.
My submissions?
To see whether that's relevant when you look at the circumstances of the case, she thinks that she's going, your argument is she thinks she's going to have a further beating, but she's in the lake, she's at distance from him, and she's grabbing for a boat or a rope. What does she think was going to come when she's at such distance from him, unless he's going to dive in after her?
I'm grateful, my lord. There are 2 scenarios in this case. The deceased could have jumped into the lake and tried to harm the appellant further, or if the appellant swam to the shore, the deceased could have easily walked back from the dock to the shore and further hurt her.
Has she ever said either of those? Because the jury would have had to determine what she honestly believed.
What she honestly believed at the time was that her life was in danger. It is the appellant's submission.
In what way, though? Did she honestly believe that either of those 2 routes that you posited was going to come to pass? Was there any evidence of that?
My lord, it is the appellant's submission that the battered person syndrome has affected the way in which the appellant thought at the time, when she was abused by the deceased at home or in any other context. It didn't seem to be the case that the violence would end after the first stroke. She was perpetually abused for some time during the fight. So it is the appellant's submissions that after she was thrown into the water, she reasonably believed that the violence would not stop. If I may proceed, I will give more information on what battered person syndrome is and how that comes into play.
Just before you do, sorry, forgive me if you interrupt. Just before you do that, so what you're contending essentially is that she went back and she grabbed the rope because she believed that that was the easiest point of safety to get back into the boat.
Correct.
Well, whereabouts was the deceased when she went back into the boat? When she grabbed the rope?
He was on the dock.
He was on the dock and he was holding the actual rope at the time.
Correct.
And so surely the appellant going towards where the rope is and towards the dock, I'm assuming, would be placing herself back into the danger zone.
So can you repeat that?
Surely the appellant going towards the rope, and this is where the deceased would be placing herself back in the danger zone.
It is not the appellant's submissions that the appellant were trying to get onto the boat, was trying to climb back on the dock. That is not the appellant's submissions. She was merely trying to get a hold of something stable to regain composure. I am not sure it is possible for us to know the exact things that she was thinking because she was under so much distress at the time. So her instinctive response was to grab onto the boat as a means of regaining composure, my lord.
Well, thank you very much. You continue.
My submissions will be divided in 3 units. First, what battered person syndrome is and if the appellant's case falls under it. Second, an exploration of the relevant case law in this area. And third, the ways in which battered person syndrome shaped the appellant's view of what was necessary. Moving on to the first of my submissions, can I please direct the court to paragraph 30 of my skeleton argument? What exactly is battered person syndrome? The term is used to describe a characteristic pattern of psychological and behavioral responses by a woman to severe inflicted abuse by her partner. The main component of this theory is the cycle theory of violence. The stages of this cycle can be found on page 31 of the printed bundle. The premise of this theory is that due to the recurring nature of the cycle, the victim is able to identify behavior by the abuser that signals the beginning of the cycle of abuse. At first instance, the appellant submits that the accused in this case was physically abused. Can I please direct the court to paragraphs 31 and 32 of my skeleton argument? Physical abuse in this case is evidenced in 2 ways. First, there is photographic evidence of a large bruise on the appellant's shoulder, which resulted from the deceased hitting her during a fight. My lords, my lady, the fact that the bruise might appear more prominently due to the appellant's vitamin deficiency should not negate its existence. Secondly, the couple's neighbors threatened reporting the couple to the police because of their fighting. Incidents such as these are only reported to the police if there is real suspicion of physical violence taking place. To preemptively rebut the prosecution's arguments on this point, the following behaviors are common in cases of domestic abuse. Victims are scared to report the perpetrator to the police because they fear he might hurt their children. Much like the accused in this case feared that the deceased would hit their child. Victims will often go out of their way to cover up evidence of physical abuse, such as bruises, because of shame. Similarly, the accused did so by wearing modest clothing to cover bruises in her torso and thighs, even in the heat of the summer. And finally, perpetrators often behave in a way that could be perceived as amicable in public so as not to raise suspicion. Much like the deceased's behavior was harmonious when the couple visited a restaurant the night prior to the incident. If the court is not with the appellant in finding for physical abuse in this case, the appellant submits that the accused was at least mentally, emotionally, and psychologically abused. I will now proceed to address 3 cases which have left open the possibility of battered person syndrome being admissible as evidence when assessing one's reasonableness of force. In other words, my lords, my lady, how could the court adopt this new approach? Can I please direct the court to paragraphs 36 to 41 of the skeleton? First, Ahluwalia 1992 established that battered women are able to adduce evidence of their abuse if they are considered psychiatrically abnormal. However, in the lack of such abnormality, the jury must still consider, and that is a direct quote, the history of a marriage, the misconduct, and ill treatment by one's husband as part of the whole story. This quote can be found on page 20 of the bundle. In agreement with the Law Commission, the appellant submits that such reasoning can be extended from the context of partial defenses to evaluating the reasonableness requirement for self-defense. Moving on to the second case of Martin Anthony, 2003, the Court of Appeal left open the possibility that, in exceptional circumstances, a defendant's personal characteristics could indeed be relevant for the objective test of whether the force used was reasonable. You can find this quote on page 2022 of the bundle, my lords and my lady. Again, the appellant, in agreement with the Law Commission's assessment, submits that the case of abused women who kill in self-defense should and can give rise to such exceptional circumstances. Third, more recently, in the case of Press 2013, the jury was directed to consider psychiatric evidence when tackling the question of whether the defendant did only what he believed was necessary in the circumstances. The defendant suffered from post-traumatic stress disorder. At this point, the appellant seeks to draw an analogy between PTSD and battered person syndrome. Battered person syndrome theory confirms that the abused woman might anticipate an impending attack from signals which have, in the past, marked the transition from the period of tension between her and her abuser to the battering phase. Thus, similar to PTSD, women with BPS can apprehend an event as a trigger of danger, even when there is no threat apparent as such to an onlooker.
Just looking at Press in paragraph 7 of the head note, is that dealing with the reasonableness of the force or the circumstances as the appellant believed them to be?
Can you please repeat the question, my lord?
Is looking at paragraph 7.
Paragraph 7 of
The head note. So on page 24, final paragraph where we've highlighted,
correct.
was for the jury to decide not the PTSD, or here the battered person syndrome, didn't affect the reasonableness. What it was the affected the appellant's perception of the circumstances. So it's at the first step, not the second. The personal characteristics are relevant.
That is correct, my lord. However, the Law Commission does specifically mention this case as allowing for an extension of that principle to the entire objective test of reasonableness. And this is the appellant's submissions here today. Does my answer satisfy the court?
So we'll find that at page 26 to 32.
In the interest of time, shall I proceed?
Yes, I can't see the reference to pressing that. No one. Yes, do continue.
May I just add that 15 minutes has concluded?
This concludes my submissions.
Thank you. Yes, Mr. Bruce.
May I please the court? I appear on behalf of the Crown as junior respondent. I will be addressing the second round. My lords, my ladies, you will find my submissions on pages 13, paragraphs 20 to 36 of the respondent's bundle. Have you found it?
Yes, we have it, thank you.
Great. Proceed. By way of introduction, I will be covering 3 points. They submitted that provocation, battered person syndrome should not be considered as evidence of a person having only done what the person's honestly and respectively thought was necessary for a legitimate purpose. Firstly, the old common law plea of provocation was abolished and replaced by the partial defense of loss of self-control. Secondly, the appellant does not meet the requirements for the defense of loss of self-control, which the appellate history found a possibility. And thirdly, provocation should not be read into section 76(7)(b). I will move past, if I may, the provocation replaced by loss of control. Is that all right by you?
Yeah.
Yes. So the principles of loss of control. The general principles of loss of self-control as a partial defense under section 54 is a 3-part test. 3 principal components of the defense set out in the Act were agreed by Lord Judge Clinton, which is also referenced in Groupina. This you can find on pages 58 of the bundle, and respectively on paragraph 5, page 132. And what was established is that each component is integral. If one is absent, the defense fails. And they should be analyzed sequentially and separately. Further on, submission 4, loss of control can be interpreted as a sudden response to an act of provocation. However, section 54, paragraph 2 has removed the suddenness part requirement, and so it allows for a delayed period to accommodate a slow burn effect experienced by domestic violence victims, such as battered person syndrome, which could possibly apply in this instance. And this was established in Anuwale 1993, which is also in the bundle, page 48. As Lord Judge Chief Justice made clear in the opening paragraph of the judgment of the court in Clinton, it is important to distinguish between the old law of provocation and the new statutory defense, which is self-contained and more limited. As per the Seniors Council submission, the appellant's actions are revengeful, which following section 54, paragraph 4 of the Fairness and Justice Act 2009, which you can find in page 25, states that the defense of loss of control would not apply if in doing or being a party to the killing, we acted in a considered desire for revenge. However, if the court does not let us in this point of revenge, I proceed analysing loss of control. Firstly, let us look at qualifying trigger. The meaning of qualifying trigger is outlined in section 55. of the Crimes and Justice Act 2009. This is on page 26 of the bundle. And essentially, a loss of self-control has a qualifying trigger if the loss of self-control is attributable to D's fear of serious violence from B against D or another identified person. And this applies if D's loss of self-control was attributable to a thing or things done or said or both which constitute circumstances of an extremely grave character and cause D to have a justifiable sense of being seriously wronged. If we look at this instance and the context of the case, although the act of throwing the appellant in Miss Bay may have induced fear and or a sense of being wrong, the background of the appellant as a swimming instructor makes it unlikely that the appellant would have felt any fear of serious violence or perceived danger in the water to fulfill the justifiable sense of being seriously wronged in the requirement of section 55, paragraph 4A and B.
So excuse me a bit, sorry.
Yes.
So does the Crown accept or ever accepted during the course of the trial that the appellant was suffered domestic violence?
It does, to a certain degree, yes.
It does. So then it's right to say then that the appellants would have experienced fear in general from the deceased.
I will cover that a bit later in the conversation about provocation. We disagree to the extent of fear. There is some element of fear, but it's much more based on a pull and throw situation rather than a sort of victim situation.
The pull and
both parties are equally responsible and equally violent towards each other, in our view.
Okay, thank you very much.
And there is a kind of pull and throw between them, which I cover a little bit later on the sort of provocation aspect.
Thank you, do continue.
Just 1 second, I missed one. Yes, so the fact that this is a swimming instructor makes it unlikely that they would have felt fear in the water, basically, or seriously wrong to cover that severity of matters. Even if she did feel a degree of fear because of the shock or the surprise that it was taken by, this would have been substantially reduced by the deceased's reaction in trying to assist the appellant by untying the boat for her to reach faster. There is also a physiological factual aspect to be noted. You mentioned earlier the shock, the water shock and what can be used to the body. It is our opinion that it's actually a shock, especially during a holiday. I mean, it would have to be a very cold water to create the kind of effect of a shock. But for us, it seems to be in line with what His Honour Judge Devlin described in Daphne 1949 as the law attaches importance to whether there was what is sometimes called time for cooling, that is for passion to cool and for reason to regain dominion over the mind. We think that perhaps the water shock could potentially have acted as a sort of cooling shock as opposed to a body shock, for her to come back to her senses to reinforce the point of the sort of the force was excessive during the pull of the rope.
And is there any expert evidence before this court to demonstrate that?
No, it's inferred opinion.
Wasn't Mr. Justice Devlin, as he then was, referring to something completely different with cooling?
Yes, a long period of time cooling. So it's a speculative comment, a sort of bracket. It was not submitted. It's a thought, let's say, that we wanted to show the court. That water can actually bring you back into your senses if you're in a temperate state.
Or if we can avoid, for the purposes of this, if we can avoid speculation and just deal with actual things that are law, unless there's expert evidence to support what you contend.
Okay, I will proceed with the next submission.
Ms. Bruce, before you do, when you talk about fear, I take your point that she may not have been fearful of water because she was a swimming instructor, but isn't the point that she might have been fearful of her deceased husband because he's thrown her into the lake?
Yes, but I think my senior counsel also covered the fact that she had also open space to swim away from him. So the fear instance in that water is not justified to that level, to an extreme level. Even if there is, it's sort of looking at it in degrees of fear, there would have been a shock or a surprise, but to be petrified, it would be, she wasn't entrapped in, let's say, a small space that there was no escape from. The water was open, she's a swimmer. It's all relative, so we think the fear element is minimal, but not non-existent. There was some element of fear, but minimal fear. May I proceed?
Yes, please do.
My lords, my lady, it is submitted that the appellant provoked and incited arguments and or conflicts with the deceased on numerous occasions throughout the trip, stated chronologically. A, the appellant refused to drive half of the way there, which does not fit the submissive and coerced profile of the battered person syndrome. B, she did not assist in carrying any items, although occupied, she could have responded in a more polite manner. The appellant slapped the back of the deceased's head, a clear and unnecessary provocation, when the deceased was trying to feed Flynn, which resulted in Flynn choking. The appellant stormed out of her tent and confronted the deceased because the deceased woke her up early in the morning. And lastly, the appellant started provoking the deceased by shouting and insulting him, at which point it is the deceased who lost control and snapped, throwing the appellant in the lake. It is the prosecution's conviction that the appellant did not meet the requirements of fear of serious violence and or justifiable sense of being seriously wronged. As Judge Chief Justice in Dawes 2013 articulated, and I quote, one may wonder, and the judge, one may wonder how often a defendant who is out to incite violence could be said to fear serious violence. Often he may be welcoming it. Similarly, one may wonder how such a defendant may have justifiable sense of being seriously wrong if he successfully incites someone else to use violence towards him. And a quote, one may wonder in this case how someone who repeatedly provoked the deceased may also fear serious violence. Moving on, the provoking acts do not themselves lead to the disapplication of the qualifying triggers in section 55, paragraph 3, 4, and 5, unless they were intended as excuse to use violence. As section 65, paragraph 6a, and it stipulates that this fear of serious violence is to be disregarded to the extent that it was caused by a thing which he incited to be done or said for the purpose of providing an excuse to use violence. A sense of being seriously wronged by a thing done or said is not justifiable if he incited the thing to be done or said for the purpose of providing an excuse to use violence. Given that the entire incident was provoked and incited by the appellant, it submitted that any fear of violence or sense of being seriously wrong should be disregarded. The series of provocation by the appellant also do not meet the profile of a battered person syndrome, central to which is fear, passivity, hypervigilance, emotional numbing, etc., as they are always afraid of their safety. And C.L. Walker, to this, if I may add an additional point to the defendant's submission, which we added in response to the consultation paper 173, which outlines Walker's theory, has two main components. The first is the psychofear of violence, divided in three phases: tension building stage, the acute battery, and third, kindness and contrite loving behavior. With this analysis, you will find, quote, the woman responds by trying to appease her abuser in the hope of preventing the abuse from escalating. And the second element of Walker's theory is learned helplessness, based on the results of psychologist Martin Seligman, which draws a parallel with dogs subjected to perceived inescapable abuse. So So the things to carry is respond with extreme passivity and inability to act effectively. And then to quote from paragraph 10.8, an abused woman perceives that she has no option but to submit to abuse. So she has no alternative or means of escape to her. The key word is extreme passivity, submission, fear, appeasing, helplessness, whereas she is provoking constantly through the case and in through the trick. So the provocative acts sort of contradict the battered person syndrome.
May I ask you this?
Yes.
If the deceased was not the deceased and survived, who necessarily would have been in the dock at a trial for this?
Apologies, would you repeat the question? If the deceased had not
If the
died?
deceased was not dead, bearing in mind the appellant was the one that was thrown into the water, in the trial, or who initially would have been charged for any assault or any violence in this particular instance?
It would have been the deceased, but they would have reviewed the same information we are reviewing at the moment, to which they would have also given notice that she was actually provoking continuously.
And so you're saying that the provocation and throwing someone into a water of what you can't say for the court or what temperature that water was a reasonable response to provocation?
It was by no means reasonable, but he would actually cover the loss of control elements much more clearly than the appellant does. Apologies, yes.
In terms of an overview, one thing that has impressed us all is that this is an entirely student-led competition between the four institutes. To put together scenarios for Moots is not easy, and then to have the various rounds to eliminate strong competition to get to any final is a lot of effort by the organisers, and anybody who also throws their hat in the ring to make a contribution and compete, because the bar is a competitive process. Those who put themselves forward for cases and competitions are those who will succeed. So well done to everybody who has entered, and particularly to the four people who arrived here this evening and competed on this. You may have had a tougher tribunal tonight than you faced before, and particularly in such august circumstances, and well done for the organisers for securing this venue. The things that impressed us were documents that thought had gone into. So what is going to assist the tribunal? You may have a lot to say. The skeleton isn't always the place for that. The skeleton is what it should be, and then to direct. So it gives flesh then to your oral submissions, and it livens up a document. The judges just want to know where you're going, and they hold something back for your oral submissions, and you can make it more interesting in that way. Know your facts, know the law that you're trying to direct on, and what's the point that you're seeking to argue. Look for consistency as well in the way you're going to present. Know your room, not just that we're in a nice old building with lots of food, but who are your tribunal, what level are they at, what is the mixture of the tribunal. We saw some good examples of pace of delivery, though, today, and the ability to think on feet, but be careful of going beyond. If you've not got an answer, say so. That's not part of the facts that the lower court decided, so it's not open for this court to speculate on what it is. So my submission on the law, on the facts that are presented by the lower court, is this. But only in those sorts of circumstances. Do not be dismissive. Take ownership of an argument that you've been given and say, well, that's somebody else's instructions, or somebody else is going to deal with it. You should be able to accept and take on the point, and be flexible. So if you've had some judicial intervention before that says this isn't a good way to go, make sure that you bank that, and then I'm coming back to that point later, maybe that's something I drop, because a good advocate is flexible. So where has this taken us to on the scoring? Well, on tonight's performance, there is a clear winner by way of team, and that is the appellants. So congratulations to the appellants. And we also have to, I'm told, decide on the advocate of the evening as well, and that goes to the junior for the appellants. So congratulations. Well done to everyone. I think we're about to be thrown out, but before we are, any questions for the panel whilst you've got us? No? Apart from where's the pub?
I think I would like some feedback on our skeleton, if possible. Do you have any comments on how to improve?
Well, one thing that I noted about the skeleton, you've taken the wrong point in there, so it might have been the right point to argue at first instance, but the lack of intention wasn't the case, so don't do that. Be careful with your phrasing. So it's 76 subsection 6 capital A, not 6, then small a in separate brackets. And actually, lenient wording. It's me being picky, but you might talk about leniency. The wider drafting or permissive phraseology might be something in relation to that. And I think at an earlier point, so page 9, paragraph 14, you've set out the elements of self-defence. The real point on this case is subsection 6 capital A, and that's the one section you don't quote in the scale. And for me, as a judge, I would question always when someone's talking to me about the law of facts and the legal argument, how am I going to direct a jury is always what I've got in the back of my mind. And just because the section set it out in an order, if I'm doing a route to verdict, the first thing you've got to decide is what did or may the person honestly believe. So that's got to be the focus. And then, was it reasonable in those circumstances? So to be flexible, just because Parliament's drafted it in the cart before the horse, it's, you've got to think about what is the process, what's the flow chart that the finders of fact will have to go through, and approach it in that order.
Thank you so much.
On the scale, again, think about the order, because bird, effectively, it's quite a long skeleton. Whereas your final paragraph of ground 1, but in fact it should have been in ground 2. The way I read it, I think it's the way you had it, sorry, not ground 2, but the use of force was pursuant to revenge. Your font seemed to change, and there were, get somebody else to go through it, because there were a number of typos in there that even spell check would have picked up. And when you're looking to obtain the confidence of the tribunal, the simple things start to undermine. And whilst it shouldn't, it's an easy way for the tribunal to be distracted. And then if they've not got that right, what confidence have they got against?
What about the content there?
Content, well, the difficulty was, I marked down quite significantly on this. You missed the point on the second part. This was not a loss of control case. When it was the Moot point says the grounds on which it was going was provocation in relation to section 76. So section 76 is self-defence, it's not loss of control. So when we've seen...
But they overlap, no? I mean, in
No.
this
No. You might... Section 76 is when you say, yes, I did it, and I intended to do it, but because the redness descended. Not, I did it because it was the only option left over to me. Otherwise, these were the consequences that I feared would happen. So when the court, any court grants leave to appeal on defined grounds, it's those grounds you argue and you lay yourself open. And actually, the flexible argument would have been, having seen what was argued by the appellants. So, well, I know I've got loss of control in there, but I can see what has been said about section 76. I've got their argument. I'm going to address you on section 76. Apologies, it's not in the skeleton, but I can pivot, which a good advocate would be able to do. And it's very hard at the level that you'll be dealing with. So the point that's being raised is actually something different, and what I put in writing is not now relevant. I will deal with this on my feet. But to have a point that isn't there on the papers and you've not got leave for, in the same way that we criticise the government to say intention isn't part of it, to say there was a lack of intention, then you need to be able to direct yourself to what the point really is, rather than just plough on in what you've prepared.
I'd also say as well, the bundle to, especially from myself that goes to the Court of Appeal quite a lot, it's clear and succinct. I remember it was a day and keep Gina Grub, and I think that she's a day indeed, isn't she?
Yes, Mr. Justice Gina Grub, yeah.
Yes. I was thanked for having a clear, concise argument. They don't like lengthy skeletons, so something that long would be frowned upon. Of course, I understand why everything is by way of a bundle, but in terms of the authorities, I mean, I suppose because you put in a bundle, you put all the complete cases in there. Generally, you just have a very clear and succinct skeleton argument, and then you extrapolate what you need and quotes from those authorities with the citations, and then you forward on the authorities. But again, I just felt that everything with the skeletons went on for somewhat more longer than necessary. It's always good to just be clear and succinct, and you will be thanked for it if they are clear and succinct, and you will not be if they are long. And I felt like chronology is very important as well. So you take the court through in a chronological order of what's in the skeleton, rather than going back and forth. So page 10 and then going to whizzing over to page 33. It's not really helpful. You need to guide your tribunal through what you're trying to argue, rather than try to confuse them. So just food for thought going forward.
I've got 3 points. A few of you asked, your tribunal to a few points, are you with me? Generally, when you ask that, you're asking for an indication of agreement with your argument, whereas you were using it to ask if we followed where you were pointing to the skeleton or the authorities. So just rephrase that, I would suggest. Try not to use your hands as I'm doing now when making your submissions. And finally, address more of your opponent's points as well, and don't concede too readily to judicial interventions.
No colloquialism, sometimes you guys are slipping in the language, which you can be, depending on what judge you've got in front of you, will pull you on it. Again, everything is done in a particular way in courts, and the more senior court you go to, the more you need to abandon certain phrases that you may have, comes with time, and what I would like to have heard is it's respectfully submitted, it is submitted. When you're speaking, some of it was like, it's almost turned into a conversation with us. You need to make a submission, and you need to tell us it's a submission, so we can address it in the appropriate way.
Yeah, it's never your opinion.
Yeah.
Which dear future.
Yeah.
And well, it's probably in the library downstairs, but if you're looking at skeleton arguments, I'd direct your attention to Myleward, which is Mylward, and Weedon.
And why?
Weldon, Weldon, 1595 EWHC CH1. So those are useful ones out when you've got a particular verbose opponent.
Thank you.
Thank you. Thank you.
Thank you so
Well
much.
done to you all.
Very well done, guys, anticipation as well.